Hello and welcome to April 2024's edition of Outline, DLA Piper's regular series of planning law webinars. My name is Trevor Ivory. I head up the UK planning team here at DLA Piper. I'm joined today by Michael Greig, who is a legal director in the planning team, based in the Edinburgh office. So we have a Scottish perspective to some of the issues that we're talking about today, as well as an England and Wales perspective. And the topic for the day is interpretation of planning policy, a topic which is a regular source of challenges and a rife ground, I suppose, for challenges to planning decisions, whether those are decisions of planning authorities or decisions of the Secretary of State and inspectors on appeal. So we're going to be looking at the correct approach to the interpretation of planning policy and how you avoid some of those challenges. In the usual way, we will keep it to, we're trying to be within sort of 45 minutes, definitely no more than an hour. If you have questions, there is a Q&A function at on your screens. Please do use that, and we'll try to answer as many questions as we go and at the end. But without further ado, let's turn to the topic. So I suppose, Michael, the starting point for any question of how to approach interpretation of planning policy has to be a case from your neck of the woods, doesn't it? It's got to be the Supreme Court's decision in Tesco stores and Dundee. That's really where we have to begin, I think.
Well, I think it's always good to start with Dundee. I think as a point of principle, only on the basis that there's not one about Aberdeen, but Dundee's good enough. Well, I mean, yes, I mean, I think prior to that Supreme Court case, I think a lot of people thought that the question of how to interpret planning policy was really a matter of planning judgment, and then the Supreme Court in the Tesco case, essentially saying that, and then the final instance that the question of how you interpret a planning policy properly at the end of the day is a matter of law. So that's our starting point. That the courts have the ability to determine whether or not a planning policy is interpreted properly, and that's a distinction from the application of policy, where if provided you interpret the planning policy properly, it's then a matter for the discretion of the planning authority to determine what weight to attach to that policy. And in that case, the courts are only going to interfere if the decision is a rational one which no reasonable planning authority could have had regard to. So that's the starting point, I think.
It's a really important distinction, isn't it? Application of policy is a matter of planning judgment. The courts will usually not interfere unless it's an irrational decision or there's been a legal or procedural error in how that application has taken place. But ultimately, the judgments being made are for the decision maker. Whereas, as you say, what the policy means, how it is interpreted, is not open to discretion. There is a correct way, is what the Supreme Court tells us in the Tesco case. There is a correct approach to the meaning of a particular policy, and that ultimately, if there's dispute about what a policy means, how it's to be interpreted, then that is a matter that the courts will intervene on. And prior to Tesco, I think there were a few examples of sort of planning authorities. It was quite common for planning authorities to perhaps interpret their own policies differently in different situations, and give us a different meaning to policy depending on the situation they were facing. That clearly was closed down by Tesco. And by that Supreme Court judgment, that is not an option. There is one way to apply a policy, one way to interpret a policy, and that interpretation needs to be consistent on every occasion.
Yeah, that's right. Well, what's interesting, I suppose, is when we come and look at some of the more recent cases, is how that concept's then been developed by the courts, and the circumstances in which the court will say that well, this is the definite meaning of the policy. It's got intrinsic meaning, and it can only mean this. As opposed to the situation where you've got a more kind of broadly based policy, which gives a lot more discretion to the planning authority in terms of what how they how it can be interpreted in terms of the factors that can be brought into play and the circumstances in which they need to have regard to certain matters, and other circumstances in which they have a discretion in terms of what they can take into account. So that's where it gets a little bit more complicated and nuanced.
I think that's right, and it's probably worth at that point just briefly sort of looking at what was being considered in the Tesco case, and it was effectively a retail policy, wasn't it, with a sequential test within the local plan, within the development plan, and the question was around the requirement to take account. The policy required you to take account of the requirements. Was the word that was used, and the debate was what did requirements mean? Did it mean the need for additional retail space in Dundee, or did it mean the requirements of the retailer and of the market? And what the court did was look at the wording of the policy and look at the wording of the text around the policy and come to the conclusion that the right approach was that it was the requirements of the market and the retailer needed to was what was meant by that policy wording, and therefore it wasn't open to what Tesco were trying. So it was actually ASDA, wasn't it, who secured a planning permission. Tesco were trying to quash it in the great store wars of the early noughties that used to happen. And Tesco were trying to argue that it should, in that case, be interpreted as the requirements of the retail need, the need for retail, rather than the particular requirements of ASDA. And that was roundly thrown out by the court. It said in that particular case, it was quite a specific policy. And that's the distinction you're drawing, and we'll no doubt come on to in a minute. It was quite a specific policy with quite clear meaning, and therefore that was the approach to interpretation. There was no leeway in the factors to be taken into account in terms of what the requirements were for the purposes of that particular policy.
Yeah, other than the other interesting point, I suppose, is that in saying that, the Supreme Court also made it clear that there does need to be an element of flexibility and realism, both by the developer and by the planning authority, so that because otherwise, I suppose what we're saying is that if a developer can insist on any scale of development whatsoever, then, well, the sequential test doesn't exist, because you just say, I'm going to have an absolutely massive retail development. It can't possibly fit in any other site. And then the sequential test, it's pointless. And that's a point that's picked up in later cases as well.
I think that's right. And that, again, is an example of the distinction between interpretation and applications. It's the requirements that you need to take account of are the requirements of the market, but you're not bound to deliver the requirements of the market. You, as a decision maker, need to take them into account.
Yeah.
As part of that assessment of compliance with the plan. There's a few introductory cases, isn't there? Tesco's is the starting point. The next one that comes up a lot in the cases and is probably just worth sort of mentioning quite close to the beginning, if for no other reason than it was my case and I was successful in the Supreme Court, so it's always good to blow one's own trumpet when one can. But that's the case of Suffolk Coastal and Hopkins Homes, which was also, that was looking, whereas Tesco was looking at development plan interpretation, the issue there was paragraph 49, as it was, of the 2012 NPPF, and the question of what was a relevant policy for the supply of housing. And there's a few principles that come out of Lord Carnworth's judgment in that case, again, as I say, a Supreme Court case. Firstly, he was very clear that there was no difference in the approach that should be taken between interpretation of development plan policy and national policy. So he quite happily said that Tesco applies equally to interpretation of the NPPF and other policy documents as it does to development plan. And so I think that's sort of just a point we may well come back to Suffolk and Hopkins at various different points, because it does keep coming up. But that, I think, is sort of a key point, which then sort of links us really through to the other case that you sort of have to start with when you're thinking about how to interpret policies. You've got to do Tesco, you've got to do Suffolk Coastal, and then you probably need to have the Court of Appeals judgment in the St Modwyn's case in mind. I'd have thought, which to my mind actually gives a really good, there's a great paragraph in Lord Justice Lindblom's judgment that summarises the principles in Tesco's really neatly, and actually avoids you having to read Tesco, frankly. You can just go straight to that one paragraph in his judgment.
Yeah, I think that's right, because I think it's the St Modwyn case seems to be the one now that's very much the one that's the go-to point for summarising the cases. I mean, I think it's got I think the Lord Lindblom's aspect of the judgment. There's 6 points in it, but I don't think we need to touch on all of them.
No. It's 4.4, particularly paragraph 4, so, and his point 4 within it that sets out really neatly, I think, the interpretation point that we're discussing today.
I think that's right. So, yeah, I mean, that's saying planning policies are not statutory or contractual provisions, are not to be construed as they are. And then it's, it's then picking up on Tesco and saying the proper interpretation of planning policy is ultimately a matter of law for the court, and the application of the relevant policies with decision makers. So that's essentially the points we're picking up earlier on. And statements of policy be interpreted objectively by the court in accordance with the language used in its proper context. So a failure properly to understand and apply relevant policy will constitute a failure to have regard to material consideration, or amount having regard to an immaterial consideration. So that kind of encapsulates and summarises, I think, the basic approach.
Yeah.
Nicely.
Yeah. So that's the kind of basic approach. It's a matter for the court, it needs to be done objectively, and everything you've just neatly summarised there. And I think that there's then different approaches, isn't there? And a case that I thought would be useful just to flag as a real example of how not to do it is the quite high profile case from back end of last year of Marks and Spencer on Oxford Street. That was Marks and Spencer against the Secretary of State, and the issue there, Marks and Spencer, existing department store on Oxford Street in London, looking to demolish and rebuild. There are a number of issues. There are heritage issues in the judgment and other points as well. But I think the key one for the purposes of today's talk is Marks and Spencer could almost be a talk in itself at another time. But in terms of how interpretation of policy was relevant, was the inspector. It wasn't an appeal, actually. Westminster had resolved to, and the line in paragraph 152. This was the December 2023 framework. But yes, so
there we go.
We're back. Minor technical hitch there. Apologies to everybody. Those watching the recording haven't missed anything. So I was talking about the Marks and Spencer case, paragraph 152 of the framework. The line in that paragraph requires, or what it says is that taking account of climate change should include encouraging the reuse of existing resources, including the conversion of existing buildings. So that's the wording that was in issue. And what the inspector had done, and then the Secretary of State maintained when deciding to refuse the application, was read into that wording a presumption against demolition, or a presumption in favour of reusing existing buildings. And that was one of the central reasons why the application was rejected by the Secretary of State, and Planning Commission refused for the demolition and rebuild. And I think the court, it's a High Court judgment, Mrs. Justice Lehman, I think, and she's pretty damning. I think, given it is the Secretary of State's decision himself, she's pretty damning of this suggestion. And the Secretary of State maintained the case through the High Court that wording that says encourage reuse created some sort of presumption against demolition. And her view, paragraph sort of 54, 55, and 56 are the real kicker for me, that must have made fairly uncomfortable reading for Gove. She says, in my view, it is plain that the Secretary of State misinterpreted the NPPF and therefore erred in law. And says there simply is that wording gets nowhere close to providing a presumption. That was her decision. There is an encouragement, but there is not a presumption against demolition. And she goes on to say that the Secretary of State relied on a meaning of the NPPF which is simply not open to him. There is, in paragraph 152, some encouragement for the reuse of buildings, but nothing that comes close to a presumption. And then just in case her contempt for his approach is not clear enough, I like the line, the Secretary of State has not applied the policy, he has rewritten it.
Yes.
This leads him to applying a test or policy hurdle through the rest of the decision letter, which is based on his misinterpretation of policy. So I think it's a sort of interesting read and entertaining to see the Secretary of State get a kicking. It's always good fun. But there is that warning in it. You simply can't read into policy more than is contained in the words. If a policy is intending to create a presumption, it's normally clear on that, whether that's the presumption in favour of sustainable development or any of the other presumptions. They're very clearly set out in the absence of that clear use of the word presumption, you simply can't take a policy and elevate its status in the way that the Secretary of State is clearly trying to do in the Marks and Spencer case.
And I think that's a theme that comes through a lot of the cases, including some of the other ones we've looked at in a little while. That what the courts are very reluctant to do is read into a policy some kind of high level and some really specific intrinsic meaning if it's not expressed in very clear words. So things like a presumption in favour of one way or the other way, or particularly at the moment, sequential tests seem to be the issue which they're grappling with quite a lot, and are not willing to kind of read those in if they're not expressed in very, very clear terms. So, and that was the problem here, that essentially you had a Secretary of State trying to make a policy that didn't have a presumption into one that did, and essentially what they're saying, well, they can't do that. That's making it up as you go along.
Yeah. And I think sort of for me, it would have been perfectly legitimate, it seems to me, for the Secretary of State to have regard to paragraph 152 and place weight on the impact in a carbon context of the demolition and rebuild. That's clearly a material consideration. It's clearly part of the policy to take account of the benefits of retaining existing buildings in a climate change carbon context. But he hadn't just taken account of it, he hadn't just placed weight on it, he'd misinterpreted it and sort of indicated that you simply couldn't go beyond it without having demonstrated that the presumption could be rebutted. So I think it's that example of where, when you're applying policy, you need to be very careful that you're applying it in the right way. If you're applying it in the right way, you're home and dry. You can place weight on it. That could conceivably have been a reason to refuse the appeal, but only if you've properly interpreted it in the first place.
Yeah, I suspect in this case there was still when you look at the kind of the way that the judge deals with the recommendation from the inspector, I think the impression I get from that is that they were saying, well, in reality, there wasn't really any way you could reuse the building. So there probably would have been an issue, I suspect, in terms of whether it would be rational, but not impossible. It's just that there would have been a difficult hurdle, I think, for Govi to do in order to do that.
It would. So he had to go at creating a different hurdle that was easy.
Made it more difficult for himself.
The High Court wasn't having much of that.
No.
You talked about a while ago the sort of the distinction between sort of broad policies and more specific policies that starts to come out in Tesco. I think it's probably useful now just to explore it, because there are two slightly different approaches depending on whether a policy is a sort of broad brush principle policy or whether it's a more specific, detailed, prescriptive policy. And that probably the Mead case sort of is a good place to start looking at the difference that the court draws there, isn't it?
Yeah, I think so. I mean, the Mead case is one of these, well, I think one of these really useful cases. It doesn't necessarily establish new law or anything like that, but it very nicely kind of looks at what the existing law is, some of which we've already discussed. But perhaps more importantly, what it does is kind of look at the practical application of the law, how you apply the law to particular types of policies, and then essentially the main differentiation then is between sort of very specific policies and then very broad brush policies. So Mead, again, this is one which was looking at flood risk, the sequential test for flooding in the NPPF, and also in the planning guidance as well, where the sequential test is amplified. So in this case, what we had was a situation where the appeal inspector had looked at the sequential test and decided that there were actually 13 other sites which potentially could be reasonably available, and that the sequential test hadn't been properly applied by the developer. So there are specific points in relation to that, but in relation to, if you like, the legal principles that we've been discussing, what the court first did was again review things on the basis of Modwin and Tesco. So again, application of policy properly interpreted as a matter of the decision maker, but when there's a genuine issue about the interpretation of policy, that's a matter for the courts, and there's logically a prior question to the application of policy. Again, picking up on previous case law, the courts saying we need to be cautious about overly legalising the planning court process, and again making this important distinction between the issues of interpretation, which is something which is appropriate for the law, for the courts, and issues of judgment, which is for the decision maker. And then so those are kind of really the principles that we've already discussed, but what the court then did was then to go in and look at things in a little bit more detail in terms of how that applies to particular types of policy. And what they were saying is that there's really kind of two general types of policies. So some policies can be expressed in quite broad terms, and where you've got a broad-based policy, then those don't necessarily lend themselves to the same level of legal analysis as a more specific policy. So the court was making a distinction between those two types of policies. And so when you're looking at a broad-based policy, the application of a broad-based policy very much depends on the facts of the case and requires the application of planning judgment. So the court's function when dealing with the interpretation of a broad-based policy can be quite limited. Whereas when we were looking at Tesco, when we were looking at the sequential test there, what we had was a very specific policy test that was issue, whereas other types of policies may be more broad in nature, and it's really a question of whether the planning authority, the decision maker, is satisfied as a generality with whether the policy has been met before, but they don't necessarily include a specific, if you like, hurdle that you need to cross that the decision needs to be satisfied of. So I think that's the main distinction.
And I think it's sort of useful perhaps to look at an example of each, and the one that they look at in Mead, it comes out of both the Tesco case, well actually it's the Tesco case, the Hopkins Holmes case, and then the Sam Smith case. All three are Supreme Court decisions, and they sort of contrast an example of a specific policy being the one in Tesco, where there's the reference to the word requirement, and then the policy explains that requirement means the requirements of the market and requirements of the developer. And they contrast that with the example in Sam Smith, where that was dealing with the meaning of openness in the context of the Greenbelt. And what they say is the Tesco one is a very specific policy. Your requirement has a clear meaning, no discretion as to what requirement you're looking at. It is the requirements of the market and the particular applicant and developer. In contrast, what does openness mean? Well, openness is much more a term of art. There isn't a definition of openness within planning policy. And ultimately, there is a much greater element of planning judgment on what openness means in a particular context. And I think what Sam Smith was saying was visual elements may well be a part of openness in a Greenbelt context, but they don't have to be, and they're not exclusive. And ultimately, therefore, when an inspector or a planning authority is considering openness, there isn't a sort of a legal definition of openness they can go to and apply. They have to exercise, it's implicit in that broad policy that they've got to exercise their judgment as to what openness means in the context of a particular case where they're applying that policy. So I think that's for me, I found that quite a helpful distinction in the Mead case between the sort of prescription of a policy telling you what a word means and a policy that sort of leaves the question open.
Yeah, and I think again there's a further subtlety that even where you've got a kind of fairly broad policy, there may still be circumstances where the wording of a policy might require a decision maker to take a particular consideration into account. Whereas in other cases, the policy may be so generally expressed that it's really a matter for the decision maker's discretion whether to take a consideration into account. So there's that further distinction, I think.
Yeah, I think that's right.
Yeah, and I think the final point in terms of the approach to the interpretation of policy for me that's helpful, again picking up on what we were saying earlier on, is that the court there was saying that a court may decide that a particular meaning is implicit in a policy. And again, they're referring there to Tesco and the sequential approach. But what they're saying is that the court will be cautious about entertaining an argument of that kind. So the role of the court is very much to interpret policy, not to make it. So if you're going to say there's an implicit meaning in a policy, then that must be very clear from the language of the policy used and the range of circumstances which the policy applies. So there's a kind of level of reluctance there for the courts to say that a particular policy has a very specific meaning unless it's very, very clear from the context. And again, that's picking up on the Marks and Spencer's case, where you can't say that a policy has a strong presumption in favour of one thing or another thing unless that's actually what the policy says. So that's just a clear example of that.
A good example of that, I think, that's sort of not the court being reluctant to fill in the gaps in policy when they're interpreting it. I have to say I can't remember the name case, but I think it's a Mr. Justice Dart decision in the High Court, but that was looking at back to housing supply and was looking at the situation where if there's been an oversupply in housing, what has to happen? So if you've got an undersupply, the NPPF at that time was very clear about how you deal with an undersupply and how it needs to be met. But the question of whether you take into account an oversupply when considering and calculating the 5-year requirement, the NPPF was silent on it. And what the court said in that case is it's not for the court to read in to policies that deal with how to deal with an undersupply the converse of what should happen with an oversupply. Policy, whether deliberately or not, is silent on how to deal with an oversupply. Therefore, that ultimately is a matter of planning judgment. There is no policy to be interpreted. We're not going to write one, says the court. Here and now, that's not our job. In the absence of a policy, you as planning decision maker have to decide how to deal with an oversupply. Are you going to take it into account or not? That's sort of over to you. So I think that's quite a good example of the court saying, no, it's not for us to fill in the gaps in a policy. We'll apply the policy, we'll tell you what it means, but if there's something missing from the policy, that ultimately is then for the decision maker.
Yeah, absolutely. And again, within Mead, the other example, I suppose, is them just not being willing to put in intrinsic meanings when they're not there. I mean, Mead, I suppose, is the kind of slightly it's almost a counter to Tesco in some ways in relation to flooding as opposed to retail, because again here it's a similar sorts of issue in terms of the NPF approach to the sequential test for flooding and the question of what was meant by a suitable site, and what the developer was trying to argue there was a similar position to what was in the position in Tesco, that it meant suitable for the particular development that the developer wanted to put forward. Whereas what the court said, well, actually, when you look at the wording of this particular policy, this was one of these broad, open textured policies, and there wasn't any additional language indicating how the issue of appropriateness should be approached. So that meant that the degree of factors that could be taken into account was very much up to the discretion of the decision maker. They weren't going to imply further tests that didn't exist. It was very much one of these discretionary approaches.
And somebody has just reminded me via the questions, the case I was referring to on how undersupply and oversupply of housing is the Tewkesbury case. Thank you for that. I knew it. I think another case that I think is an interesting example of that sort of broad policy approach and the reluctance of the court to then to start sort of imposing prescription into it is the concept that comes up time and time again, actually, in planning appeals, particularly residential appeals, is the concept of valued landscape for the purposes of the framework. And the framework, right the way through from the 2012 version, has always contained this reference to valued landscapes, but has never prescribed what a valued landscape is. And the case, the Brownlee Solar Farm case, I think is an interesting exploration of that, where an inspector had considered the question of whether a landscape was valued. It considered factors like the fact that it wasn't designated, and he acknowledged that there was no specific designation applying to the landscape, but didn't regard that as determinative, and went on to consider other factors, including what appeared to be very strong feeling locally, that the landscape was of value or was valued by local people. But his ultimate conclusion was, taking everything into account, it was not a valued landscape for the purposes of the framework, and went on to determine the appeal accordingly.
Mm-hmm.
That was challenged by the third parties, by the objectors who were looking to be more prescriptive around what a valued landscape was. And again, a High Court decision, Mrs. Justice Lang, saying no, there is no prescription in the policy. There isn't anything in the framework or in planning practice guidance that tells us what a valued landscape is. Therefore, the intent of the policy is for the decision maker to have a discretion, and to take into account, whatever he or she thinks is material, and whatever is put before them, in terms of coming to that judgment on whether it is a valued landscape. So I think that's a very clear example of a broad policy, and therefore the court really seeing its role in interpretation as quite limited, and not wanting to start to take away that discretion from the decision maker.
Yeah, well, Brownlee is interesting on multiple levels, I think, because it also grapples with use of agricultural land, which is very much a big issue in terms of solar development, which is what the case was all about. And again, the third-party challengers were arguing that I think it was paragraph 13 of the PPG required the applicant to show the proposed use of agricultural land was necessary, and they suggested that the only way to do that was through a sequential approach, to demonstrate there's no sequentially preferable sites that don't involve use of agricultural land. And again, what the court said was, well, no, there's no reference within the policy to a sequential test. We're not going to read that into it. The PPG doesn't mandate the consideration of alternatives. It doesn't require a sequential test to be adopted. I think what's in, the court was very clear, saying where a national policy requires a sequential test, then it expressly provides for it. And obviously, the obvious example is the ones we've looked at, really, the retail sequential test, the flooding sequential test, in the absence of such a clear expression, the court's not going to read that into it. It's going to be a matter for the discretion of the decision maker to be satisfied whether the applicant as a whole has demonstrated that the proposed use of agricultural land is necessary, which is quite helpful for. So the good decision, quite a helpful one, certainly I think for solar farm developers, where the whole issue of use of agricultural land has become very politicized.
Another one I think that is interesting is another one from your neck of the woods, the wildcat case.
Yeah, it's always good. Again, I said it was good to have Dundee. It's good to have a thing about wildcats as well. It's not not something that comes up every day.
The Scottish wildcat population.
Yes,
made its way to the court of session, at least in Scotland.
Well, it did. Yeah. So again, this is one about interpretation of biodiversity policy, and again, it's in a sequential issue coming up again. This is the Scottish National Planning Policy Framework, which is interesting itself, I suppose, in that now the NPPF in Scotland, contrasting to England, is now part of the development plan. So it's got elevated status. But nevertheless, the point is, notwithstanding it's got elevated status, the legal principles that apply to the interpretation of it are exactly the same. And again, it's interesting, I suppose, that the court of session here was looking and directly applying the cases that we've been looking at. The Modwin case was the one. Those paragraphs in Modwin were the ones that they applied. in terms of setting out what the legal tests were for interpretation of planning policy. So, in terms of the particular policy issue here, a specific part of the biodiversity policy required the secretary, the Scottish ministers who were determining the application here, to have regard to various criteria in terms of whether the development would leave the natural environment in a demonstrably better state than it would be without development. And one of the factors that had to be looked at was the developer's assessment of potential negative effects, and that they should be fully mitigated. And the important point was fully mitigated in line with the mitigation hierarchy, which was then defined within the NPF itself. And the third-party challengers here argued that the impact of that requirement for full mitigation in line with the mitigation hierarchy required the decision maker to, again, adopt this kind of sequential and weighted approach to mitigation, so that the Secretary of State had to be, sorry, the Secretary of State, Scottish ministers. I'm getting all Anglified here, which is not inherent in my approach to things. Never mind. The Scottish ministers had to be satisfied that the mitigation hierarchy had been followed, so that measures to avoid impacts were applied in preference to offset measures. And what they said is that approach hadn't been followed, and so Scottish ministers had misinterpreted their own policy. But what Scottish ministers argued was that, well, no, the policy only required a developer to identify negative impacts and fully mitigate them, and it was then up to the decision maker to determine whether effects have been fully mitigated or not. Again, it was a similar approach to other cases that we've talked about. So the court was essentially saying, well, we're not going to imply additional sequential tests unless that's clearly expressed here. Now, and they just weren't satisfied that that was the case. The decision maker's view on whether negative impacts would be fully mitigated was the fundamental question. It didn't require it required a view in the round in terms of broad-based policy. It didn't require you to tick off specific aspects of a sequential-based approach. And interestingly, what they did was they kind of rationalized that by looking back at the consultation on NPF4, because what they were saying is, well, if you're imposing, if what the result of if your interpretation is correct, that's a fairly fundamental change to the approach to biodiversity impacts. If there's now a sequential based approach and previously there wasn't. And what they said was, well, there's no indication from any of the consultation on NPF or any discussions that was the intention. So they seem to play a reasonable amount of weight. They placed a reasonable amount of weight on that point, that there had been no indication that such a change in policy had been envisaged.
And then I suppose we ought to look at some examples of more specific policies that we've sort of explored there, a few of the broad ones where the courts are reluctant to get involved. And I think one that is fairly recent, a decision from last year against Somerset Council, which I think the decision actually was Mendip. The next two cases are both going to be about Mendip Council, but this one was Mendip, although by the time of the judgment, Mendip had become Somerset through local government reorganisation. But so it's the Moore case, Moore and Somerset, that I think is interesting. Now, I have to say, the judgment is mercifully short, but notwithstanding it being mercifully short, I find it a really difficult judgment to read.
Yeah,
I get very excited about what the difference might have been had a comma been imposed or if a comma had been moved. And by the end of it, I was like, I don't know what's going on. So not one I recommend anybody read unless they want to just get themselves tied in grammatical knots. But I think the interesting point that there was around back to retail, actually, to some extent. There was some policies governing where retail was to be delivered within the town frame. And there was a dispute between the parties as to whether the references were to the town centre or whether they were to a broader area. And I think the court was very happy there to intervene and drew on the word. The court interestingly accepted that the policy was quite confusingly worded, and was quite ambiguous as to where development was being directed, principally retail development being directed. But as a result, was willing to go behind the policy and take other factors into account, in order to come to what Mr. Justice Jay thought was the proper interpretation of policy, i.e. that it was predominantly directing development into the town centre.
Yeah, I think you're right. I mean, there's some of it looks like sort of it's like the marking of an English essay or something like that. There's so much about punctuation, but because I think essentially it's almost like initially the court comes to a kind of gut conclusion that this is the way it should be read as a matter of English. But then what he then does is he goes, yes, okay, but let's have a think about what the policy is actually all about to see whether that's actually the right result. Because I think the issue here was that the site we were talking about here would constitute a very large proportion of the town centre. So I think what he was saying as well, the requirement is essentially whether 50% of the retail or office requirement it was being required on this specific site or within other areas. So it makes sense that you would say the 50% would be on this site because it constitutes so much of the town centre. And frankly, if it's not going to be 50% on this site, well, where on earth is it going to go? And I think the difficulty is that the planning authority didn't seem to have an answer to that. So that kind of backed up his interpretation. But I think it illustrates, I suppose, the approach to interpretation. One about use of English in terms of, I suppose, what it shows is how easy it is to get a policy to say something you don't intend it to mean just because you don't have a comment in it, or because you don't make it an additional bullet point. It's very easy to change the meaning accidentally. So there's that point, that kind of practical point that you really do need to think quite carefully about your English and your punctuation, or you could get a kind of a decision that you don't want. But the other point, I suppose, is that it's not just about English. It's about looking at what's the purpose of this policy, and does what actually makes sense when you look at the wider context. And I think that it's useful from that point of view. But again, like I say, notwithstanding it's a very short case, it's one that's really quite difficult to read and get your head around what's being said.
But it's sort of interesting. I think that one of the points that really comes out of it for me is we're told time and time again, we're told in Tesco, we're told in Suffolk Coastal by the Supreme Court, you give the words of the policy their ordinary plain English meaning. You don't look behind the policy. There's always a reluctance to look at the documents submitted to an examination in order to explain a policy. They say the policy should be capable of being interpreted on its face. And so time and time again, we're told that. But here, because the policy just isn't clear on its face, and it doesn't matter how hard you try, it is open to interpretation because it's been badly drafted. The judge is willing to say, well, this is my gut reaction as to what it means, but I am going to take into account extraneous factors. And I think for me, what was interesting is it wasn't so much looking back at the documents that explained why the policy says what it says, but he was looking at it in the wider context of saying, okay, this is a development plan policy that's been found sound, and one of the tests of soundness is it's in broad compliance with national policy. If you look at national policy is very clear on retail. It's town centre first. You concentrate your retail development within town centre, then you look at edge centre. It's a test we keep coming back to today. And so he said, in that context, this policy wouldn't make sense if this policy was advocating 50% of the retail needs being met outside the town centre. That just, whilst that is an interpretation that it is possible to read into these words, it simply doesn't make sense in the wider context of that broader policy context. So I think for me, that's interesting because it's an example of, yes, the courts are very clear. You don't go behind wording the policy, you just give it its plain English meaning. but just sometimes it's so impenetrable you can't. English doesn't help you because it's poorly drafted, and at that point, the court is willing to look at other things to try and help give the policy a meaning and give it effect.
Yeah, I think that's right. I suppose also in a more general sense, I suppose it's just an example. What we had here was a very, I suppose, quite a specific policy requirement that 50% of the retail use had to be met somewhere. And so the question is, well, where? And that's something that had a very specific meaning that the courts are going to need to find an answer to. So it's different to the other cases we've looked at, where again those are the more broad-based policy decisions. It's a narrow express requirement which needs to be interpreted before you can actually apply the policy, and that's a matter of law for the courts. And I suppose, whereas with the other cases, the court's interpretive role was much more limited in terms of what's the scope of the policy, of the broad-based policy, what the parameters within which the decision maker needs to reach their judgment. And I suppose what the courts are saying is that with those broad-based policies, we more quickly arrive at what the parameters are for the decision maker exercising their judgment. Whereas when we're dealing with a more specific policy, like in Moore, there's a necessary first step that you need to take before you can actually get on to exercise judgment. You need to understand what that policy means in a very specific way.
Yeah. Just conscious of time, I think the last case that I just want to talk about was another Mendip case, now Somerset Council, but it's one we've talked about on previous outline in a different context. But it's the Norton St Philip Parish Council case, and this was a question of interpreting policy in the context of a local plan examination. And what had happened was Mendip, as then were bringing forward part 2 of their local plan, which included the allocations. Part 1 of the local plan had already been adopted, and for various reasons, the policies in part 1 had included a requirement for the identification through part 2 of an additional 505 dwellings, which was to deal with the fact that the plan got extended by a few years late in the day. So suddenly the housing numbers that it was aiming to meet didn't quite match up with the requirement across the whole of the plan period. In that context, Mendip, some of the larger, to the northeast of Mendip, you've got what was Bath and northeast Somerset, and there's some big towns in Bath and northeast Somerset on the boundary with Mendip. And what the inspector was saying, and what local plan part 1 said, was that when looking at where to put those 505 homes, consideration would be given to the northeast of the district, notwithstanding that if you looked at it just as a district, that was the middle of nowhere. But actually, in reality, it was connected to some sustainable settlements the other side of the council boundary. So the requirement was to include consideration of the northeast part of the district in the part 2 of the plan. When it came to the examination of the plan, the inspector came to the conclusion that part 1 required these 505 homes to be delivered in the northeast of the district. And initially, the council disagreed with the inspector and said, no, that's not what the policy says. Policy says that we have to include consideration of the northeast, but it doesn't say we have to put these houses in the northeast. But the inspector maintained his position and required a modification to the plan, and required the allocation sites in the northeast of the district. Norton St Philip Parish Council was one of the councils that then had land allocated as a result of that, and they challenged the adoption of the plan on the basis that the inspector had misinterpreted the policy in part 1. And the court, Mr. Justice Holgate in the High Court, was very clear that absolutely that was not what the policy said. And given that the wording was clear, given it was a specific policy as to how these allocations were going to be considered and identified, he had no hesitation in stepping in and saying, no, there's no discretion in how you interpret that policy. The policy is clear it does not require you to look at solely the northeast. It requires you to look at the whole of the district, including the northeast, and that's a fundamental difference. So on that basis, he quashed that element of the plan and upheld Norton Phillips' case. So it's an interesting example to me of sort of where sometimes you just a decision maker just reads the policy wrong, and at that point the court doesn't hesitate to step in, it seems to me, and correct that error.
Yeah, and I suppose it's also illustrating the point that this issue of how you interpret policy is not just relevant when we're looking at planning applications. Okay. It's also relevant when we're looking at a development plan making. So that particularly if you've got a multi-layer development plan with a higher tier plan saying this is how things should be approached, then that needs to be interpreted properly when the lower tier plan is being made, or the whole thing can be challenged potentially. Yeah,
I think that's right, and it's you sort of end up feeling a little bit sorry for Mendip in that case, because they're trying to tell the inspector he was wrong, but then their plan ends up getting partially quashed as a result of the inspector sort of not doing that. What the court says there, interestingly, just as an aside, is the court says, well, what Mendip should have done is seek an urgent JR, seek a declaration during the examination process to confirm what the correct interpretation of the Part 1 policies was, in order to avoid the risk further down the line that ultimately transpired of them being subject to a legal challenge. So I think it's if you can see others erring in their interpretation of policy, I think one of the points that comes out of that case for me is you need to think proactively about how you avoid that mistake happening. If you're going to protect your planning application, if you're going to defend your decision, or if you're going to get your plan adopted, sort of you shouldn't passively sit by and allow an incorrect interpretation of policy to prevail. Great. Well, that I think brings us nicely in time for the end of the session. So thank you, Michael, and thank you to everybody who has joined us. Apologies for the technical issue in the middle there, but hopefully that hasn't affected anybody trying to watch the recording at a later date. We'll be back next month in May. I'll be joined by Ian Graves on the 9th of May, I think, when we'll be talking about the habitats regs and the many pitfalls of appropriate assessment and the other aspects of habitats regulation. So hopefully you can join us then. But in the meantime, thank you and goodbye.
Thank you.